Hear ye. Court of Appeals of the 14th District of Texas is now in session. Pursuant to adjournment, adopting the Constitution as called to order.
Thank you. Please be seated. Before we start oral argument, we have one factual question that we're hoping you agree on. And the factual question is with respect to the fence and the adverse possession of that piece of property. Does the judgment cover from the cinder block wall to the edge of the property, or does it go from the wooden fence to the end of the property?
Or something else.
Does anybody know the answer to that question?
Yes, so our argument has always been that the judgment is too indiscreet to really show what was adversely possessed, and that kind of leads into our argument about the declaratory judgment.
Okay, well, it has meets and bounds attached. What are the meets and bounds? What do the meets and bounds cover?
Well, there's a different starting common boundary line in the survey that is attached to the judgment than it was stipulated to, and there's also the property extends past the fence, so that common boundary line, depending on where it is, would be more or less West Harbor's property. So that's why we've always maintained that it's in distinction of the actual common boundary, and counting from that line based on the stipulation makes it too indiscreet.
Okay, and what is your position as to what the judgment actually says?
Our position is that the judgment only gives up the part between the existing fence and the boundary line.
Okay,
that
the wooden
cinder
fence.
block is not relevant, that narrow strip, if you look at this, this is where the cinder block fence was in the dotted line. This is a triangular portion here, and it was very clear from our testimony at trial that we were not seeking the additional property between the fence line and the, where the cinder block was.
So the green on this chart, it was the cinder block,
Correct.
and the next red line is the wooden fence.
The wooden fence. And everything up to the wooden fence, which is basically our concrete driveway and parking lot, is covered.
Right, and
there's a small part of it that goes over the boundary line, and it operates.
do
like
you agree that you cannot tell from the judgment?
I believe the judgment is clear on that point.
Okay, I mean, it includes meets and bounds. Does the meets and bounds match this, what you're telling me? Because, you know, obviously we can't tell, and we couldn't really, your argument focused on the cinder block line, not the fence line, so we were confused.
That's my understanding, Your Honor. We'll confirm that, and if that's wrong.
But it's certainly something that you all agree on, that it should only be the wooden fence and not the cinder block line.
From our standpoint, absolutely.
Well, the record shows that even that fence runs onto lot 35.
Well, no, I understand that. I understand you disagree that there is adverse possession.
Yes, Your Honor.
But you agree that the only part that they're claiming was adversely possessed was from the fence, not the cinder block.
Yes, to the extent that that part of the property, the fence is there.
Okay. All right. How much time would you like for rebuttal?
5 minutes.
Okay. We're ready when you are.
May it please the court. My name is Sarah Churchin, and I'm here on behalf of Appellant West Harbor, LLC. The primary issue in this appeal is whether Orleans Harbor, whom I'll refer to as the Association for Clarity, is entitled to West Harbor's land, which I'll call Lot 35 for ease here, under a narrowly applied equitable exception to the statute of frauds known as the easement by estoppel doctrine. As the Supreme Court's dry opinion tells us, the elements of an easement by estoppel are a representation that was communicated by the promisor to the promisee believed that communication, and the promisee relied on that communication to his detriment. And this court repeated those elements in the Stallman case. The easement communicated must be certain, precise, and clear, and all elements must be met at the time of the alleged communication conveying an easement. Here, there is no evidence of a representation conveying some kind of easement. Certainly not a general recreational easement, and certainly not certain, precise, and clear. The trial court's judgment awarding the association an easement must be reversed for several reasons, which I'm going to map out quickly before I discuss each. Texas courts apply this exception rarely, and they call it a nebulous doctrine. It's been applied only in a narrow band of cases. And the reason is because the purpose is to prevent fraud and protect innocent parties, and here it's undisputed we have no allegations of fraud. Second, as I mentioned, we have no affirmative representation of an easement interest. That's wholly absent here. The only reasonable conclusion drawn from this record is that in 1987, the relevant time, the association obtained an agreement from its neighbors on Lot 35, the owners, that they would not interfere or obstruct with Orleans Harbor, the association's construction of a new bulkhead, because it would be very expensive to do from their own property, and they asked their neighbors if they could encroach for that limited purpose, to rebuild the bulkhead. Nothing in the evidence shows any discussion of a general recreational use or an easement, a realty right in that peninsula that was on 35, Lot 35. Even if, for argument's sake, we can say that it was, this neighborly agreement was an easement, the scope of that easement, as the memo shows, is to rebuild the bulkhead.
What is your response to their argument that the easement is necessary because of the, the requirement or the inability to access the water from any other area on the peninsula?
They can access the water from their side too. Different parts of the peninsula are shallower than others, but they have access to Lake Austin. They can construct stairs as they have on the other side if they want to, but that too was not discussed at this meeting. Nothing was discussed about general recreational use, and we know from the dry opinion that is fatally indistinct. We need certain, precise, and clear conveyance of an easement interest, and we are lacking that here. Turning to that memo, we see that the value conferred in this neighborly agreement all inured to the association's benefit. They reaped a huge savings, cost and time-wise, to rebuild this bulkhead by encroaching on Lot 35. It was an order of magnitude, as their engineer said, and they filed this memo, their engineer filed this memo, relying on it in the property records that Lot 35's owners would not obstruct or interfere with the rebuilding of the bulkhead. That's all that memo says. Testimony from those there in 1987 confirms that no one thought they had acquired a realty interest, a right to use the land. At most, they thought they had permission to use it, though we don't even have any direct evidence that that was ever said. The association, as it did in its brief, is going to point to years, decades of use as its happy place on the peninsula with weddings and fishing, but none of that is relevant. That evidence actually came in support of their easement by prescription on the easement, and the jury found against them on that claim. So that evidence doesn't really go at all to easement by estoppel, but even if it did, it wouldn't matter. It's irrelevant because it's not at the time of the alleged conveyance, which was 1987. Also, any passive acquiescence, which was a big deal in the briefs, is also irrelevant here because we have no specific representation and we don't have a vendor-vendee relationship. Now, we don't think the court even needs to answer whether Scott is binding authority here or whether Scott was correct in holding that there must always be a vendor-vendee relationship, and that comes from the Supreme Court's Storms case where it was in the context of a purchaser.
Well, we have to follow Austin law.
Right.
And if Austin law requires the vendor-vendee relationship, you win.
Right, that would be an easy way to dispose of it. But if the court doesn't want to worry about circuit splits or how 41.3 applies when you disagree with the law of the transfer court, you can also not worry about it because we don't have an affirmative representation. And as the association concedes, there's no Texas case that says You can have an easement by estoppel in the absence of either vendor-vendee relationship or some kind of affirmative representation. And going back to this general recreational use that we have in the amended final judgment, we don't know what that is. In dry, it was even more specific than this because they had an oral representation of some rights to use portions of the property that they didn't own. We don't have that here either. We don't have anything to guide us in the enforcement of this easement, which was the inherent danger in such a broad, fatally indistinct easement that the Supreme Court was primarily concerned with in dry. So I
Well,
wanted,
we're talking about a pretty small strip of land, unlike 1,000 acres,
right,
right? I
Right.
mean, and, I mean, how many feet is that little section there?
So I think the record in looking, in some places I've seen 50 feet, some places I've seen 70.
No, I mean your property, your client's property.
I believe that is a 50 foot.
50
to
foot?
70 foot.
Of the whole peninsula?
This little
Your
strip.
client's is wide.
From the whole running
No,
the
wide.
length.
Not
wide.
long, wide.
Wide. It's a couple feet, yes. Yeah, but the concern there is how would we enforce it? Say they wanted to build a 3-4 story launching pad for some kind of water activities, and it obscured Lot 35's ability to see beyond that, or is that general recreational use? We don't know. The parties couldn't agree to what they wanted in the final judgment. The final judgment is so indistinct, we don't know how we would enforce it, which is the same issue in dry, and in fact in dry we have more guidance on what this easement right was than we do here. Here we have nothing. We have only a neighborly agreement, which this court has said neighborly agreements are mere permission inconsistent with a claim of right. And that's what we
Certainly
have.
there are lower court cases that talk about access to water across someone's land, an easement for access to water across someone's land. How do you distinguish those?
Because in those cases they are landlocked easements, and here this is not an easement by necessity. It is, the peninsula is covered by water all around it, and they still have access, as they've shown in the pictures. You can see they're fishing, not from that, as you pointed out, small strip of the peninsula, but from around the peninsula. So they're not landlocked in any way. It's just a matter of whether they have a right to general recreational use, which in their mind includes whatever landscaping they want to put, not letting Lot 35 put fence or landscaping of its choosing. That's all we have so far, but we don't know what general recreational use means, which is what the Supreme Court based its opinion in dry on. And I'm running out of time here, but I just wanted to quickly point out in our exhibits, we have the two competing surveys, and this gets to the question you asked before. The cinder block fence is wholly on Lot 35. The fence, which they built in 2014, meanders. Now, how far it meanders onto Lot 35 depends on which survey you look at. The survey attached to the final judgment is the Delta Land Survey. The survey that the parties stipulated to is the Carson survey, the whole Carson survey. And there is a different, if you look at the two pictures side by side, it speaks 1,000 words. There's a different starting place, and whether that fence, whether it runs all the way onto the common boundary line, whether it deviates, depends on which one you're looking at. And that's why we continue to argue throughout trial that the claim for declaratory relief to declare that stipulation as the whole Carson survey controls did not moot our claim, because we insisted in our motion for JNOV said that attaching to the final judgment a different survey is antithetical to the stipulation and is fatal to the enforcement of that judgment. So I'll return and I'll see you in rebuttal. Thank you, judges. Good afternoon, may it please the court.
So, I'm just going to ask you a question. Different survey attached to final judgment than the one agreed to? Is that correct?
That appears to be the case, but my understanding is, and we can get it corrected if need be, but my understanding is that our client was very clear at the trial that they only want the land on their side of the fence. and where it might meander over into the other property, they want to make sure that that is protected, because that has been adversely possessed for 30 years. Originally by the cinder block fence, and then we moved it back. We're willing to give up the rest of it that's on their property. Just so you have a kind of visual of this. It's
But
not.
why didn't you agree to it in the trial court and get the judgment correct, if this is the case?
Well, this is the first time I've heard this argument, so I'm gonna have to go back and look at it.
Okay.
So but the
All
way.
right, sorry to, you can start over now.
No,
I
no,
just had that one question in my head.
Absolutely, and if we need to get it fixed, we will get it fixed, because there's a simple answer to it. The way that this property is laid out is it's on Westlake, and there are 2 gated mechanical fences that are protected access. No one can get onto West Harbor, well, either property, frankly, without, by just going there. There's gated access from the road. And alongside that gate is the wooden fence. And going all the way up to the fence is the paved driveway / parking lot. It goes all the way up, literally, I was just there, to the fence line. And that's all that we're asking for, is to the extent that there is a small portion that meanders over into lot 35, that is what we proved adverse possession to. And this idea that that somehow changed in 2014 when we built the wooden fence, if anything, we just gave up part of what we were adversely possessing. But we still have had continuous, notorious, conspicuous, visible use of this part going up to the fence line for 30 years. No one else can access it, because you'd have to go through the gate to get to it. And the fence is about 9 feet tall. So this is not something that someone could just walk up to and get to. Lot 35 doesn't have access to our part of the fence, and we don't have access to theirs. So that is an enclosure, what the Supreme Court talks about. It is an enclosure that protects that property. If I could turn to the easement, the peninsula easement, because I think that's really important. There's some things that are critically important for the court to understand here. And that is, this is the boundary line. And in 1987, we had a choice. We could have built the bulkhead on the boundary line. That was what we were prepared to do. And what consequence would have been if we had done that? This would all be underwater, including the old bulkhead. No one owns the water. And why is this water so important?
Well, it wasn't underwater at the time you began construction, was it?
No, but if we had built the bulkhead, because this is higher than the water. The land goes higher than the water. If we had built the bulkhead here, this would be covered with water.
But how could you build a bulkhead on someone else's land? The land was there.
We wouldn't have built it on their land. We would have built it right here.
But
Built it
it's not
up
on the
from
water.
there, and it would have been covered with water. And there was very little water at the time. We built this land. We're the ones who backfilled. What we did is we went in and put a bulkhead north of the existing bulkhead, the wooden one that was failing, and reinforced. Very expensive proposition. And they asked us to. That's part of this conversation that is so important. They did not want us putting the bulkhead here because they knew it would damage their land. There would be excavation.
My understanding is that it would have been much, much more expensive to have just put the bulkhead where you're talking about on the land on lot 34.
Well, both sides benefited, absolutely. I mean, we approached them being good neighbors, and also because we thought this would be a good solution. They agreed. They wanted this, and then we went in and backfilled. They didn't pay for any of this. We built it, we maintained it, we created it, and we have done everything to take care of it for the entire time since 1987, and there's never been a problem. But we could have avoided this problem by just putting the bulkhead on our property line. They asked that we not do that because that would have damaged their property and the still water. And they would not have this strip of land right now that we're fighting about. So the promise that we would go on and do something of this magnitude without having access to the water or the bulkhead for even repair purposes, because that's the proposition. I mean, under their theory of the case, they could build a 6-foot wall right here on the property line that we created, and that is injustice. Easement by estoppel is designed to prevent injustice. So this was not passive acquiescence or silence like the cases that
Except for the fact that you knew you were building on their property.
and they agreed to it.
But it was their property.
Yeah, but they wanted us to do it. They wanted the bulkhead here. And what this has done, the reason this is so important is because all lake water is not the same. This is Lake Austin, right? It's a narrow strip of the Colorado River. Boats go up and down. There's a lot of turbulence, a lot of waves. This is not safe water. You can't put boats in here very easily. You'd never let your kids swim. This is not safe water.
And who testified to that?
James Welch, our president of our homeowners association. I can give you sites.
So what you're saying is that you need access to safe water?
Just safe water, because this is where we put the paddle boards in. This is where we put the kayaks in. You let people swim or tube. And this is public area.
So-
Anyone can go on this area.
So this picture, PX 01.8, doesn't really show roaring water on this other side.
Well, there's not a boat there, so that may be why.
But, I mean, it shows gravel here and ending.
Well, the way this looks,
On that side.
It shows kind of a protected
if you look at
cove.
Google Earth, this might be an
Well,
easier.
you need to find me an exhibit, because I'm looking at this exhibit in your record.
Right. Well.
PX 1.8.
Okay, and what you're looking at on the wide part is the lake itself. That's where the boats are going back and forth, and they're going pretty close to the end of the peninsula. If you go back here, this is heading towards Orleans Harbor, which is actually a man-made harbor, and the homes go around the harbor. But this is safe water, but that's where boats are going back and forth to get at lake access. The safe water for swimming and for recreational purposes is here. And it's been used that way by the homeowners association for 37 years. So this idea that recreational use is some sort of amorphous topic, all they have to do is look at what they've been doing for the last 37 years. Kayaking, fishing, swimming, paddleboarding.
But how would that be any different from the ranch case, where they could say for years, we've been fishing, we've been walking, we've been hunting? I mean, it's the same concept.
Well, not exactly, because the only purpose of this peninsula is recreational. If you look at the picture on page 2 of our brief, that has a pier coming out from the peninsula. What's a pier used for? Docking boats and fishing, swimming. It's a recreational purpose. That's the only thing.
But it's on your side, the pier.
It's not clear from the picture. The pier came out from the peninsula. Because, again, this was built. This land was created by us and has been used by us for these purposes. So it's not an amorphous concept here. And there was plenty of testimony about the way that this was used. And no one, until 2019, when this property was purchased by West Harbor, no one has ever interfered with our use. And we've protected the use. We've put out signs. We've asked people to leave when they've gone on the peninsula. It's 100% recreational use. And it's a very specific type of use. It's lakefront property. This is the only point in the entire Orleans Harbor facility that has access to the safe water. The rest of it is all on the turbulent side of the water, and just being there, as soon as the boats go by, the waves get very high, and that's why it had to be built up so much, and that's why this land could have been solved as a problem. So why would we have done this?
What picture in the record shows me what the peninsula looked like before you did your work on it?
I think the one on page 2 is probably the best picture. But
Page 2 of what?
Of our brief. It's PX. What is the number?
No, I'm talking about an actual picture, like PX 23, which I found useful to sort of understand what this place looked like.
Oh, here we go.
This is PX 24.
Here.
This picture is PX 24, Your Honor.
Kind of hard to see.
Yeah, but you can't, you say that part of it was underwater, but I could not tell, so I tried to pull up something that looked like PX 23, that looked like it was a pre-construction, pre-bulkhead picture.
And the pictures are somewhat difficult to follow, because in some of them the water looks like it's land when it's actually just very shallow water. It was a low point.
Kind of look like a harbor type thing in here.
That's why we put together this depiction, so that the court could see.
Well, I'm still having a hard time understanding how you could put a bulkhead on someone's land. So that's why I wanted to see a picture that showed their land was underwater.
I think,
And if you could, you know, you can supplement, that does not help, it's too far away to give me a good picture. Like I said, this was a close-up picture that I found in the exhibits, PX 23, that, you know, doesn't show what you're describing, so I was confused.
I'll see what I can find and
Okay.
supplement the record.
And
So-
whose bulkhead was it anyway in 1987? Because I mean, if the bulkhead was to the Lot 35 side, wouldn't it have been the responsibility of Lot 35 to have built it up?
I believe it was their bulkhead
Okay.
at the time, but it was, I'm not sure the record discloses who put in the bulkhead. It had been there for decades. But at the time, we agreed that we would build a new bulkhead. It was needed, and this was a mutually beneficial situation for both Lot 35 and Lot 34 owners. So
But
they
no-
agreed to it.
But no easement was ever entered into any kind of property records at that point?
Not a written easement, but that's the reason there is easement by estoppel.
And your building permit says you're building only on your lot, doesn't mention Lot 35.
Well,
For the easement, the building permit for the bulkhead, which I thought was an interesting fact.
But they included the agreement in the record, the memorialization of the agreement that we could have
With the
unobstructed
building
access.
permit?
That was filed in the property records. I mean, it wasn't like this was hidden from view. And the easement by estoppel is the relationship between the two parties. Clearly, the owners of Lot 35 understood what was going on and appreciated. And the bulkhead was not constructed overnight. It would have taken, you know, months to build.
How do you get around the vendor-vendee issue?
Well, we do not believe that the third court has definitively held a vendor-vendee relationship is required in all cases. The only cases in which it has held that are cases involving passive acquiescence or silence, which is not the case here. They had a conversation. We have a memorialization of that conversation. And there was quid pro quo that was being traded. You know, you can have access, but why would you ever build on someone else's property if you were doing it just for them and they were going to cut off your rights? I mean, that had to have been part of the discussion and the reliance. Clearly, we wouldn't have done it without that. So, the cases, even the case that is the seminal case, Scott versus Cannon, by Justice Kidd, he wrote a later opinion in Vinson that they don't address in their reply brief, but it's the same Justice Scott Kidd, who found in an affirmative misrepresentation case, he didn't find any requirement of vendor-vendee. You can't find those words in the Vinson opinion. And there's another opinion even after that where the same thing happened. So there's, I think, a question even in the third court. And you know, we've demonstrated that there's really no theoretical, I mean, there's no justifiable basis for having a vendor-vendee relationship in an affirmative representation case. It doesn't make any sense. No one's ever really articulated a reason. The best that Scott Buchanan does is focuses on the word purchaser from the Supreme Court's decision in Storms, but the Supreme Court didn't focus on that. The Supreme Court has never come up with this rule, and almost every other court in the state, including this one, has gone the other way. I do need to bring the court's attention to the Weddington case that just came out of Amarillo in July, and in that case, it was also a docket equalization case, and at the rate these cases keep getting docket equalized out of Austin, I don't know that we're ever going to get an en banc decision resolving this. But in the Weddington case, the Amarillo court held that following the third court, let's see if I can find that. Yes, it's 2024 Westlaw 3588585 at page 3. It found that the third court's precedent required this outcome, but I read the briefs in Weddington, and they never made the argument that we're making. They never cited Vinson. All that the appellant said was Scott is wrong and it shouldn't be followed. Well, that doesn't help y'all because you have to follow the third court's precedent. So we're giving you a way around it because I think it's the right way. I think it's the law in the third court. I would make this argument to the third court if given the opportunity, but we haven't been able to. One last point, if I could make on the justiciability issue.
Yes, go ahead.
We raised
the idea of stipulating to the boundary line early and often, even 4 months before trial in our plea to the jurisdiction, we specifically said we've offered to stipulate. We don't care where the boundary line is. That's not important to us. What's important to us is that under anyone's version of the boundary line, we're over it for both the driveway.
But you can't stipulate 4 months before trial and just wipe out attorney's fees on a declaratory judgment action. I mean, that does not strike me as a fair resolution on a declaratory judgment action.
It was never an issue in the case, Your Honor. I mean, the point is we needed to decide where the boundary lines were. In their reply brief, they've raised 4 or 5 other claims that they claim were improperly dismissed by the court, and those claims are either restatements of the jury findings against them, or they're irrelevant to the case. I don't think anybody's claimed that West Harbor has a right to Lot 34.
Well, correct me if I'm wrong, but didn't you originally seek to exclude Lot 35 from the easement, from their aspect of the easement?
Only from Lot 34. Well, they're asking for a stipulation on Lot 34, not the easement. The easement is on Lot 35 entirely.
No, didn't you try to exclude them from the peninsula completely at the beginning of the lawsuit?
Yes, but that's...
And when clearly part of it is theirs.
But that's not the declaration that they're seeking on page 29 of their reply brief. The declaration is West Harbor does not own any portion of Lot 34. It's not in dispute. They can't get attorney's fees on that. And we did offer to stipulate. We were trying to narrow the issues for trial. This was not a situation where we said uncle at the last minute. And even the cases that they cite don't support.
Well, your plea to the jurisdiction was that the issue was moot. So not that there was some sort of defect in what they were asking for. And my question is, you can't just agree at the last minute after someone has incurred a bunch of attorney's fees to try and get this declaration to avoid attorney's fees. I mean, that you had a plea to the jurisdiction and said that the issue was moot because we all agree to what the boundary line is.
Correct.
You can't do that 4 months before trial to avoid attorney's fees, in my opinion. But you know, now you're telling me that that's not the declaration they sought?
Well, I mean, that's one of the declarations. That's the only declaration that's at issue, because these other four that they came up with are either decided by the jury verdict or irrelevant to the case. But they haven't.
Well, the only one that was moot was the boundary line one, right?
Correct.
Under your logic, the only one that was moot was the boundary line.
Correct.
Okay. But you dismissed their entire declaratory judgment action through a plea to the jurisdiction.
No, we only moved on that one ground. The other claims were not part of our motion.
Okay, so their declaratory judgment action then, because they lost on the easement and the adverse possession, would be denied, but it's not in the final judgment, right?
Correct.
Okay.
I want to quickly get to this idea of injustice. When the record shows that in 1987 they had an inevitable expense and they saved tremendous money and time by going onto their neighbor's lot to build this bulkhead. The owners of Lot 35 did not ask for it. That was their subsurface ground under the water, which is what the bulkhead attaches to. And they gave neighborly permission, which is how Caskey refers to it in the record.
So you are agreeing that your lot was underwater at the time they put the bulkhead in?
The bulkhead, the portion of the peninsula on 35 is reclaimed land under the water.
So it
35
was
or 34?
Oh, sorry, Lot 35.
Okay, so your lot 35, was underwater at the time they put the bulkhead up.
Right, and it saved them money and time. They would have had to tear down and rebuild their entire bulkhead if they did not come onto our property. And the memo that memorializes that understanding makes clear that the purpose of that agreement was to rebuild the bulkhead. And there is no evidence in this record that there was ever some kind of communication by act or deed that they were getting an easement on that property for their use for any purpose, let alone general recreational use.
Okay, so plaintiff's exhibit 23, which showed the old peninsula area, that the wooden bulkhead that used to be there was all on 34's line at that point?
That's correct. Right. So, as this court has said in Stallman, lakeside launches, if there is no affirmative representation or any conveyance of an easement, passive acquiescence is not sufficient to support easement by estoppel. At best, that's all they have. They got a boon by being able to use this property for all these years, and they assumed from that use that they acquired a right, but the elements of easement by estoppel are not met. And they got this free use if they wanted, you know, they could have paid for this land to be able to do whatever they wanted on it, but they didn't. The reliance was not based on any representation. The detriment, I don't see one, because they saved a lot of money by building this, saved a lot of time, and then they got free use of their neighbor's land. And they cannot show that they have a right to that land under equitable principles because they don't meet the elements. Moving quickly onto this issue about the declaratory judgment. They did stipulate on the eve of trial, which was a big reason why we were emphasizing this claim for attorney's fees remained live, even if there was an argument that the declaratory judgment was moot. We don't think it was moot. We think the final judgment in this case that attaches a survey that variates from the stipulated common boundary line shows that. And if you look at the final judgment refers to the survey. The survey runs from the cinder block wall, not the wooden fence. And the cinder block wall is on lot 35, but the wooden fence, depending on which survey you look at, meanders on or off of lot 35, depending on whether it's the Holt Carson survey as the common boundary line or the Delta Land survey, which is the one that is attached to the judgment. We argued in the trial court, we pointed out in our briefing, that is inconsistent with the stipulation, and it shows that this issue of the boundary line, the correct boundary line, was hotly disputed before trial, throughout trial, and they would say, we'll stipulate that's the correct boundary line, but nevertheless, their adverse possession claim continued to be tethered to how much of lot 35 did they adversely possess. If that fence is not solely on lot 35, and it's not, or lot 34 rather, and it's not, then we don't know. The stipulation was necessary to agree to a common starting point, and the fact that the final judgment attaches the Delta Land survey instead shows that that stipulation did not render that declaratory judgment claim moot. And a big reason why West Harbor filed that declaratory judgment action was because it was concerned about its own rights on its own land that it thought was dictated by the Holt Carson survey. But throughout trial and even now, there is still this indication that the common boundary line runs from a different meets and bounds, which is, if you look at it, the Carson survey is 52 degrees, 10 minutes down the line, and the Delta Land survey is 54 degrees and 21 minutes down the line, which we also cited in our briefs. This is not a sufficient legal description, and it shows why we needed that stipulation to be rendered in a declaratory judgment so that it could control this case and save all these fees about fighting over what land was adversely possessed. And even if it was moot, as I said, that this court's Elliott opinion says that attorney's fees remain live on a declaratory judgment claim, even if the issue is mooted. And if that's all, I just ask that you would reverse the trial court's judgment on the jury's award of a easement by estoppel and adverse possession claim, and also that you reverse the trial court's dismissal of our plea of the jurisdiction on grounds of mootness, and either render judgment on that declaratory judgment claim and remand for attorney's fees, or remand them both. Thank you very much.
Thank you. Thank you for your arguments in the case. The case of West Harbor versus Orleans Harbor is submitted, and we are adjourned.
All right.